What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. And we do have your UFC antitrust lawsuit fixed for you. And this is in regards to the lawsuit filed by Kajan Johnson and CB Dalloway, which mirrors the Kung Lee UFC antitrust lawsuit, which was filed in 2014. Now, Kajan Johnson and CB Dalloway filed their lawsuit in June of this past year, and it is essentially related to the same claims that Kung Lee and the former UFC fighters had filed back in 2014. The current lawsuit by Johnson and Dalloway relate to more of a forward timeline as opposed to Lee's lawsuit, which foreclosed a lot of athletes in 2017. So Kajan Johnson and CB Dalloway's lawsuit relate to Zuffa's dealings that were talked about in the 2014 lawsuit, post 2017 to the current timeline. It also includes Endeavor in the lawsuit simply because Endeavor took over control of Zuffa when the Fertitta brothers sold their shares to Endeavor a couple years prior. So what's happening in the Johnson-Dalloway antitrust lawsuit? Well, in September, Zuffa filed a motion to dismiss Johnson and Dalloway's lawsuit, citing similar issues that the attorneys for Zuffa had pointed out in the Lee motion to dismiss. Now, you recall that Judge Richard Boulware denied the motion to dismiss Zuffa, the lawsuit by Kung Lee, way back when. But similarly here, Zuffa argues that the lawsuit filed by Kajan Johnson and CB Dalloway essentially just mirror Kung Lee, like it's a cut and paste. And essentially, it states that plaintiffs' mixed martial art industry remains frozen in time, arguing that their claims back in 2014 are the same here in 2021. Now, the Zuffa argues several issues in its motion to dismiss. First off, it talks about the fact that Endeavor should not be in the lawsuit. The reason why is that Endeavor did nothing wrong, according to Zuffa's attorneys, other than just purchasing the entity. So that's the first argument, is that Endeavor should be dismissed from this lawsuit filed by Johnson and Dalloway. The argument goes that simply because Endeavor was the next in line to purchase the UFC, it's somehow liable for another's actions. Well, we'll talk about that in a second. The other thing that they talk about, second allegation in his motion to dismiss, is that the plaintiffs, Johnson and Dalloway, fail to plausibly demonstrate that the UFC has monopolized the alleged output market for the promotion of mixed martial arts. In Dalloway and Kajan Johnson's lawsuit, there is a difference in the definition of the fighter market. The Zuffa contends that the definition is incorrect. Another issue that Zuffa argues in its motion to dismiss is that certain claims made by Dalloway and Johnson are time barred. The legal theory of latches, essentially stating that even if you had a cognizable claim, it's too late to make that legal argument. Time barred. It's like a statute of limitations. And this relates to, in the complaint, they talk about UFC's 2011 acquisition of Strikeforce, which is time barred under the antitrust Clayton Act, because there's a 4-year statute of limitations. Similarly, it says in the lawsuit, plaintiffs' allegations concerning UFC's use of threats, intimidation, and retaliation are copied from Kung Lee's complaint and concern alleged behavior in 2006-2011 timeframe. You recall some of the big things that were in the Lee complaint was Dana White saying that he buried this organization or that organization. There was a banner stating world domination, a headstone for pride, things of that nature. Those things happened way back when in the 2000s, and Zuffa argues that Dalloway and Kajan Johnson cannot bring it up in their 2021 lawsuit. And finally, the plaintiffs they argue that plaintiffs' new market definitions are woefully under-inclusive, excluding reasonably interchangeable subtitles. So it's essentially stating that their market definition is incorrect. A big thing I want to point out in the motion to dismiss, aside from the fact that they attempt to protect Endeavor, shield Endeavor, the new buyer in this case, because they claim that it is merely just the entity after acquired for the UFC. They attempt to state that the market has changed in MMA, meaning that organizations like Bellator and the PFL and One Championship have all made strides in the MMA industry and are viable competitors to the UFC. And this would seem to combat the argument of Dalloway and Johnson that the UFC has foreclosed markets for fighters to make a decent wage. Essentially stating that you have Bellator, you have One, you have PFL, you have all these other options out there. So in Zuffa's motion to dismiss, they outlined several organizations that have the money to fund fighters, which comes down to the issue at hand in the Lee lawsuit and in the Dalloway Johnson lawsuit. They mentioned Legacy Fighting Alliance is an American promotion broadcast on the UFC's internet broadcast subscription service and is operated by a prominent manager in professional MMA. Titan Fighting Championships is promoted by a quote-unquote multimillionaire. Invicta Fighting Championships is run by a veteran of the MMA industry. Bellator is quote-unquote the second largest MMA promoter in the world after the UFC. They also know of Bellator an enviable roster of new prospective athletes and well-known free agents from the United States and abroad. So they contend that there are competitors to the UFC, which rebuts the argument that the UFC has foreclosed markets by purchasing competitors, as well as restricting fighter movement in the industry of professional fighters. So in Dalloway and Johnson's lawsuit, they identify two relevant product markets. And so the first input market is for professional MMA fighter services. And the second, the output market, is for the promotion of live professional MMA bouts. So the definition as set forth by Johnson and Dalloway for a professional MMA fighter is a person who is compensated as a combatant in an MMA bout. The difference between that definition and the Lee definition is that in Lee, they noted that it was elite, professional elite MMA fighters. So that market definition was made broader by Johnson and Dalloway, apparently. So one of the things that Zuffa talks about is the failure in this lawsuit to allege monopoly power. So in the Lee lawsuit, you recall that there were a lot of examples that were brought up, specific examples brought up in which there was a monopoly on the use of fighters based on restricting the athletes' movements due to things like restrictive contracts, and then the monopsony power, which relates to the output market. But let's talk about the monopoly power first. Although these according to the complaint, although these allegations may have been sufficient to survive on a motion to dismiss in 2014, the exact same allegations cannot support follow-on claims seeking damages from 2017 through the present. And as I stated before, Zuffa identifies that in light of public information revealing a market that has changed dramatically since 2014, it notes that there is less evidence of a monopoly on the part of the UFC. As it relates to the monopsony claim by Johnson and Dalloway, the UFC argues that the changing landscape of the industry would negate the claims made by Johnson and Dalloway, which the UFC argues, Zuffa argues, are the same, exactly the same as the ones made by Lee in the 2014 complaint. So Zuffa argues that there is more buyer power on the part of promotions from 2017 on, since 2017, which would negate a allegation of the UFC and Zuffa's monopsony power over the buyer market. So this is where PFL One Championship, Bellator come in as stronger competitors within the buyer market that they could buy for free agents. So you could think of things like Anthony Pettis going to PFL, Rory McDonald going to PFL, Bellator signing guys like Yoel Romero and others of that nature, Chris Cyborg. Obviously, you can argue from a plaintiff's standpoint that these signings from the PFL and Bellator were related to other reasons and not because they were free agents out there. It's a debatable question, and it'll be interesting to see how the parties address those specific facts as we go forward. But here, Zuffa argues that those allegations were not specified in Dalloway and Johnson's complaint. Moreover, they just essentially say that Dalloway and Johnson regurgitated what Lee had argued in its initial complaint in 2014. And they leave that up to the court to decide. Now, with relation to the time barring of threats and retaliation, that is something that will be a bone of contention, because essentially Dalloway and Johnson do relate back to the 2000s and to that Lee complaint as far as the market domination by the UFC with the buyer and seller market. So there's a contention by Zuffa that those actions in this lawsuit filed in 2021 should be barred by statute of limitations. Also, going over the motion to dismiss, they continue to talk about and argue that the market for professional MMA fighter services defined by Dalloway and Johnson are not properly defined. So Zuffa argues that the plaintiff's suggested input market fails to include obvious sources of MMA athletes, vis-a-vis prospective professional fighters and fighters based outside the United States. Secondly, the plaintiff's allegations rely heavily on the undefined concept of top-ranked fighters, a metric that is too amorphous, according to the lawsuit, and vague to plausibly define the relevant market. So in the motion to dismiss, they go on to argue about how vague the adjective of top ranked would be to define this particular market. Now, last week, the fighters filed an opposition to the lawsuit. Opposition to the motion to dismiss. Plaintiffs contend that Endeavor had a role in the antitrust lawsuit, and that is why they are party to the lawsuit. Despite the fact that Zuffa argues that they were just the mere owner and sued by plaintiffs due to that, Dalloway and Johnson state that Endeavor took an active role and perpetuated the antitrust violations. In one sentence from their opposition to the motion to dismiss, it cites that Endeavor negotiated and executed PPV, media, and sponsorship agreements on behalf of the UFC and its fighters, and that the scheme has inflated the UFC's pay-per-view prices significantly above competitive levels. They also note that Endeavor assisted in negotiating the fighter contracts, and as a result, continued on with the furtherance of the scheme. The Johnson and Dalloway lawsuit, according to the opposition to the motion to dismiss, states it was made for two distinct reasons. One, to hold accountable Endeavor, the majority owner of Zuffa since 2016, for its active involvement in suppressing fighter compensation. More of that in a bit. Secondly, it also says it's to preserve the rights of fighters injured by defendants' conduct after June 30th, 2017, which I believe is the more important part of the issue here as it relates to plaintiffs, and perhaps the overall strategy of the fighters that are seeking relief from the court in relation to its dispute with Zuffa. In its opposition to the motion to dismiss, realistically, Johnson and Dalloway utilized some of the arguments made by the Lee plaintiffs back in 2014 related to its arguments concerning its monopsony and monopoly claims. As far as what happens next, the plaintiffs Dalloway and Johnson note that they're not opposed to consolidating the cases, meaning moving their case in with Lee. So thus a little bit of an expansion of the timeline and time frame for which the alleged violations occurred. So instead of a timeline from when it started in, I believe, 2014 through June 30th, 2017, we get it expanded to sometime in 2021. Or even or 2020. I'm not quite sure. I'd have to check on that. But anyway, it's an expansion of the timeline in which the alleged monopsony and monopoly allegations exist. It will be interesting to see how the court handles this lawsuit, mainly because a lot of the discovery that has already transpired in the Lee lawsuit will be relevant in the Dalloway and Johnson lawsuit. Now, there is going to be a fight regarding what is relevant and not relevant in the current Dalloway-Johnson lawsuit as it pertains to the Lee lawsuit. Again, there was an issue related to latches. Dalloway and Johnson deny the allegation regarding a statute of limitations violation, maintaining that it's a perpetuation of the antitrust violation. There are going to be a lot of legal theories here bandied about. One of the legal theories that will be argued in this present lawsuit filed in June 2021 is the perpetuation of the antitrust violation, the continuation of a violation. This would probably mean a lot of relevant documents could be used by plaintiffs, while Zuffa will argue that there needs to be a foreclosure of some of the evidence because they are barred by statute of limitations. We shall see what happens here. There is no hearing right yet as far as a date for which this lawsuit, this motion shall be determined. You could imagine that it will happen fairly soon, hopefully in November, as far as actual hearing, maybe. And then we'll see if there will be any action involved as far as a decision made. You might recall that it took over a year for Judge Boulware to come down with a written opinion, although he had said in the actual hearing of oral arguments that he was denying the motion for summary judgment. So we shall see what happens. As you are beginning to find out following this antitrust lawsuit from Lee and now this one from Dalloway and Johnson, this is a long path to go. This is Jason Cruz of The Legal Submission. Have a good one.